Hello and welcome to May's session of our Comerica and Shofner Consulting Lunch and Learn. This month, we're talking about brand decisions and how that relates to trademarks. So one of the first decisions you have to make when starting a new business is branding. What's the name of the business going to be? What is your logo going to be? And are you going to have a slogan? While this seems like a marketing issue, it's actually highly integrated into the legal issue of trademarks. So first, we're going to talk about just the basics of a trademark, how trademarks impact your company's branding, and what you as a small business can do to help protect your business's brand using trademarks, and how to avoid some common trademark pitfalls. So just the basics. A trademark is intellectual property that's intended to protect against customer confusion and consumer confusion. What we're trying to protect with the trademark is the recognition that people have in our small business. I hope that when people hear Shofner Consulting, they think small business lawyer. We know that when people hear Nike, a lot of them think of athletic shoes and clothes and other sporting goods. When people hear Apple, they think about computers. That's because the brands, Nike and Apple, have trademarks, their names and their logos and their slogans, in Nike's case, just do it, that help consumers just immediately think about the brand when they hear or see those marks. So as I kind of alluded to, they apply to company names, brand names, logos, and slogans. Sometimes we have brands within a company. This can also go to trade dress, the packaging of a product, some more very distinctive characteristics. That's kind of trademarks 301, extra advanced. But so for right now with small businesses, mainly we're looking at names, logos, and slogans. The US only allows trademarking businesses that exist. There's one small caveat called an intent to use application. If you have something in the works, you can file an intent to use. However, every 6 months, you either have to renew that intent to use application by paying a fee or say that you're now using it. So I think the timeline between the initial filing, the waiting time to get through the initial period, plus all the 6-month extensions, 4 or 5 years that you can kind of sit on an intent to use application of a trade name or trademark, but it's not a terribly long time, considering some other countries allow people to trademark things immediately. So in the US, we're looking at businesses that exist. We don't want people squatting on trademarks like they sometimes do with domain names. So trademarks are divided up to 45 classes of goods and services. There are more goods than services. These are based on the Nice Convention that happened in Nice, France in the 1950s. So as you can imagine, some of the categories are kind of stale, and some businesses now that exist in today's world don't fit cleanly into any particular class of goods and services. The categories inside each of the 45 classes have been expanded to kind of fill out and change as the times have changed. But just know that sometimes we get into a little bit of a where exactly do we fit because the classes are so old. You do have to register for every class that's appropriate in order to have protection in that class. Something to think about is Delta. When you hear the word Delta in a business sense, what do you think about? Do you think about the airline? Do you think about the faucets? Those are two very big, very well-known brands with the exact same name. They can coexist because they're in different classes of goods and services. So sometimes I'll have people tell me like, oh, well, this already exists, but whatever they do is way over here. It has nothing to do with your goods and services of your small business. It might not be an issue, although it might, because as we'll see on an example later on, a lot of times businesses have multiple classes that they fall into. So sometimes they're okay for a while, but as their businesses grow, they run into issues when they start offering new goods and services. So as we're part of the point of this presentation is that when you're developing your company's branding, its name, its logo, working with your marketing or your branding or your PR agency, it's really important to know what's out there. Know what's out there in your market, in your industry, in your geography, but also know where you want to go, because it really can lead to big issues. Trademarks are not guaranteed. On top of having to make sure that there's not another company in your class that has the same name or mark or something confusingly similar, you can't trademark things that are descriptive. So Shofner Consulting is considered somewhat descriptive. My last name is Shofner and I run a legal consulting business. So that kind of just says what I do. And so we try to get into things that are more arbitrary, fanciful, or very distinct. So again, go back to Nike. Nike, I believe, please don't quote me on this if I'm wrong, I believe that was one of the Greek or Roman gods. So it's a word that existed, but that didn't really have anything to do with sporting good wear. Apple, obviously Apple, one word, very descriptive when you're talking about fruit, but when you're talking about computers, it really has nothing to do with anything. So that's why it's considered arbitrary and possibly even somewhat fanciful. So when you look at my logo up here in the corner, that's sort of a fanciful mark. It's not real descriptive of a law firm. It's just kind of a picture that I am creating an association with. And so when we're looking at trademarks and naming our business, the law firm of Kelsey Shofner is not going to be trademarkable. It is descriptive. And it is also, when you get into names, sometimes names are a little questionable. That's kind of like Trademark 201, a little bit more advanced in this presentation. But arbitrary, fanciful, and distinct is what you're going for when you're trying to choose a name, logo, and slogan. A common misconception, something I hear from people is, well, I was able to register the business at the Texas Secretary of State with that name, so I'm fine. I have the trademark in it. I'm not infringing on anyone. No one's going to infringe on me. Or I got the domain name. So the deal with this is, for one, the Texas Secretary of State is one of 50 secretaries of states in the country, and then one of hundreds, maybe thousands of regulatory bodies across the world. So just because the business does not exist in Texas under that exact name, and to be clear, the Texas Secretary of State allows names that are much more similar than the Trademark Office does. That's not going to give you inherent trademark protection, nor is it going to prove that you haven't infringed on anyone. Now, having the name does help you create your trademark and give you the common law protection and show that you're using the name in commerce, but it's not a given. Same with domain names. Especially now that there are so many subdomains. We've moved past .com, .org, .edu into hundreds, thousands of domain. And so there's usually a way to kind of get around that and find something that works close enough for your business. But on top of that, people can just buy domains. People buy domains and sit on them for years, hoping to either start a business or maybe just sit on it to sell and make money. It's a business tactic for some people. So just because you're able to get the domain does not mean that there's not another business out there that already is operating with that name. So we've kind of started to get into this, but I thought that an example would help how the ability to trademark a name or logo can really impact the branding decisions that you're making now. So here is a small business. We have a restaurant, and lots of restaurants, at least a lot around me, like to have merchandise. Pretty easy to print up your own t-shirts. Excuse me, just got a little ahead of myself there. It's pretty easy to print up your own t-shirts, maybe some koozies or beer glasses, print them up for a couple dollars each, sell them for 20 bucks, and then you have people walking around with your restaurant name on it, doing free advertising for you. Then we also get into having our signature dish, our signature item, where we would really love to be able to bottle that beer that we brew in-house and sell it at the local beer store, or get our pasta sauce onto shelves. So when we look at all this, just when I was kind of off the top of my head, thought of 5 different categories that a restaurant may need to consider. So obviously the big one, providing the food and drinks, that's class 43, it's a service. But then the other 3, t-shirts, hats, merchandise, and then different types of food are all different classes. And food in particular has at least 4, if not 5 different classes it could fall under, sort of depending on what that food is. So if you're running an Italian restaurant and you would like to be able to sell t-shirts and hats, you would also like to one day have your own line of olive oil, pasta sauce, and then perhaps your signature drink mix that you could sell. You're going to need to look at 5 different classes. So the first thing we do, this is something that either trademark attorneys can do or small businesses can do themselves, is perform a knockout search or an in-depth search. An in-depth search is something you probably want to have a trademark attorney perform. We have access to some services that help us look at a much deeper level. A knockout is going on to the Uspto's website, searching for current applications, current registrations, and past registrations. And we'll talk a little bit more later about what's included in a knockout. But even the in-depth searches that cost a little bit of money can really help, because it can look at things like the subdomains, what other domain names are owned. I know I've had clients who said, well, I Googled the name and no one else has it. Okay, but no one else has that exact name, but do they have similar names? Or do they own the domain Shofner.consulting instead of shofnerconsulting.com? And so there's a lot of nuance there. Plus we have businesses that have existed for a long time and have brand recognition, but have never actually applied for their trademark. They do have some rights in their name. You cannot just swoop on top of them just because you're filing the application. Patents, first to file. Trademarks, more nuanced, a little bit more first to use. So when we put a little bit of money in now to doing these trademark searches, we can really save thousands of dollars down the road. You start using a name that someone else has the trademark for, either through common law or registration, you're going to get a cease and desist letter. There's someone monitoring that name, and they're going to send you a letter that says, stop using this name. And then either you have to say, okay, fine, and rebrand, or you have to fight it. Either way, that's going to cost a lot of money. Rebrands are expensive. Hiring someone to come up with new names, slogans, logos for you, then putting it out online, on social media, on print media, reprinting all of your business cards and stationery, even though a lot of us don't use a whole lot of paper anymore. I know I have business cards, I have pens, I have notebooks, I have stuff with my name on it. I want my branding out there. I have my Yeti that my husband gave me for Christmas. Like, well, do I have to go change this if my logo was actually belonged to someone else? I mean, I'm not giving it to anyone, but I probably shouldn't use it anymore, right? And like we showed with the restaurant example, it's really helpful to know where your business is going. Sure, you might be 100% wrapped up in a tidy box for your current business, but if you have plans to grow, you need to know what's out there. And that's where those intent to use applications can be really useful. So we file an application for our name in our main business, our restaurant services, but then we go intent to use those different merchandise categories, so that as we start to develop our merch and our pasta sauce and our olive oil, we're able to be on top of those. So coming back to that example, so we're cool with our name, with the restaurant. There's no other restaurants anywhere in the country with that name. Honestly, highly unlikely, but that's another topic for another day. But you want to be able to manufacture and sell packaged food. What if there's already a company out there that's manufacturing packaged food for distribution in grocery stores? They might have nothing to do with the restaurant. They might not even be your type of food. But if they are in that class, most likely the USPTO is going to consider it to be too similar and not allow you to use that name. On the other side, we've got clothing. Again, your restaurant name could be good for the restaurant, could be good for all the different food. No one else is using it. But then you want to start selling t-shirts, and there might be a clothing company that's using that name or something similar, or a logo that's similar, and the PTO is not going to allow that. So how do we avoid these issues? What can small businesses do in order to prevent potential trademark and branding issues down the road? Captain Obvious, Google it, but don't just Google the name. Google the name, similar names, mix it up a little bit. Google image search for your logos. This is not 100% effective, but it's maybe 50% effective. And if you can catch one of those just by Googling, you've saved yourself a ton of time and effort and money. The next kind of advanced step is to go to the USPTO's register. It's called the test database. They've made it pretty user-friendly for non-attorneys to use, and you can see what marks are out there. Names, logos, slogans, alive and dead. So ones that have either been applied for, approved, and then expired. Trademarks only last about 5.5 years before you have to renew, and ones that were applied for but not allowed. And you can see what classes they're in. So maybe there is a business in the USPTO register that has your exact same name, but it's a completely unrelated goods and services, different class number, different categories. At least you can kind of get a feel for what the USPTO might do. In our digital world, looking at social media handles, there definitely are social media handle squatters out there, like there are domain name squatters. So just because someone has the handle doesn't mean they're a legitimate account, but we all know that there are a lot of businesses that sort of only exist in the social media world, and they might have some common law trademark rights in their name, even if they haven't really moved outside of Instagram or TikTok or whatever platform they're on. In addition, on the flip side, maybe it's just a person who has no intention of monetizing or creating a brand, but if you can't get the handle, you're gonna have a bunch of people tagging some other brand. It can lead to issues. So you wanna make sure that those handles are available and not going to create confusion, even if they're not going to create a trademark issue. There is no international court for figuring out who should have the social media handle. There kind of is one for domain names. Again, that's an advanced topic. There is a little bit of international recognition that domain name squatting is an issue. Social media handles are basically a free-for-all. When you're thinking about names, think about something arbitrary or fanciful. We've talked about Apple. So if you want to open a restaurant and you want to call it the Italian Restaurant of Dallas, that's not going to work real well. If you want to call it Kelsey's Italian Restaurant, it's probably also not going to work real well. So we want to think about something that's a little bit more arbitrary, fanciful, distinct, maybe doesn't necessarily have super descriptive. Of course, you want people to know they're going to an Italian restaurant and not name it like Kelsey's Tex-Mex restaurant that serves Italian food. But think about what you can do that's a little bit creative with the name or the logo. A lot of people like using online logo generators. They're inexpensive. Some of them even advertise you can do it yourself. I would argue that if you have any intent to trademark your logo, this is not a route to go because it's going to create something that's either too generic or too descriptive of in your industry. So then we kind of move into the more advanced, slightly more expensive. You can always hire a trademark attorney to create an opinion letter. When someone hires me to create an opinion letter, I do a search using the software that's available to me. There's several different levels with several different price points, and it really depends, of course, it depends on how much the client is willing to spend, how much I sort of think this might be kind of iffy. So let's dig a little deeper and see. If it's something that just is totally off the wall, outlandish, we don't really think there's anything else out there, maybe we do something a little bit more surface level, just to double check, check ourselves. And then I write a letter that says either I think there is a highly likely chance this is approved, likely chance, somewhat likely, or this is a pretty big business risk. A really quick caveat, the USPTO is not known for its consistency. It's honestly really hard to give an opinion on if something is going to be approved or not, because there are a ton of factors that go into it, including kind of whoever you're dealing with at the USPTO. However, generally, an attorney is going to be able to tell you, look, there's like 4 other businesses with this name. Do not go there, choose something else. Or yeah, I have a good feeling about this, and here's how we can write the application so that there's a higher chance that it gets passed. So I'm not saying don't do it, but just know that it's not infallible. Nothing in the law is infallible. If anyone's told you otherwise, whole nother story. Okay, we can file intent to use applications. We've done our searches, we feel good. We can go ahead and do those intent to use applications. As I said, it's a little bit more expensive. There's a USPTO fee, you're gonna have attorney's fees, but if you have a really great brand name and you're just not quite ready to launch, it's well worth the money to get that protection going and get in line on it. You can use TM for something you're claiming a trademark in. The R with a circle around it is for a registered trademark. You cannot use that until you have received that registration certificate for the USPTO. But TM, of course, before you use this, make sure that you have checked that there's no one else that has a registered trademark or brand name in your industry that could fall into the same class that you would cause infringement on. But if you feel pretty good about your name and you just haven't gotten through the registration process yet, using that TM puts others on notice that you're claiming the common law rights in that name and that you have an intent to go ahead and trademark it, get the registration on it, so that you start building that book of evidence that this name, logo, or slogan has consumer recognition in your brand. And then I really do suggest filing that registration application as soon as you can afford to. I've alluded to it that there is common law rights in the US. If you're interested in what that means, I have several blog posts about that on my blog, about how you can create a little bit of trademark protection in your brand when it's new, but you shouldn't be waiting several years to file an application. Get yourself up and going, feel good about your concept, file that application. If you were unable to afford the intent to use on the front end, but put that higher on your to-do list than a lot of business owners tend to. They tend to not think about it, but as we've talked about, it's really important to have that protection in your name and your logo so that you don't have to go through the rebranding and you don't have to go through any sort of trademark dispute. So as I'm getting at here, at Shofner Consulting, I do work with small businesses to help protect their intellectual property, including their trademarks. I can perform the knockout searches for you. I can also do in-depth searches with advising. We can talk about the likelihood of your mark getting approved and what it might mean and how we think it might go in the next 2 to 5 to 10 years. I can help you file applications. While it is not required to have an attorney file an application at the USPTO if you are a US citizen, it's extremely helpful. This is a very nuanced type of law. And yes, of course, people have done it themselves. Of course, people have used LegalZoom and succeeded. But just because you can doesn't mean you should. Using an attorney is really going to help you avoid the issues down the road, make the process go smoother, quicker, and be less expensive. Then once you have that mark, whether it's registered or something that you're claiming common law rights in, monitor it. You have to pay attention to who else is out there using your brand's name and logo. If it is causing infringement on your business because of the class, or if it's not, and making a decision about when to go into trademark protection mode. So those of you that have joined before know that I do legal risk audits and strategy sessions for small businesses. I do flat rate legal projects, and I have a monthly in-house counsel subscription. I would love to speak with you about working with your small business on all aspects of small business law, and particularly trademarks. So please feel free to reach out to me. My contact information will be at the end of this presentation. And in the meantime, next month in June, we're going to be talking about intellectual property, some other types, copyrights and trademarks, how those are really important to your business as well, and what you can do about them. So thank you for your time. I hope this was informational. Please feel free to reach out to me. Email is best. If you have questions or would like to schedule a consult, also please follow me on LinkedIn and Instagram. I post a lot of just little tidbits of information for small business I hope are valuable to you as your business grows. Thank you.